The second stage of the appeal is for the Charity Commission to respond to the information that you've given in your notice of application. They have 28 days to do that after you've sent in your notice of appeal, and we send them a copy of the notice of appeal so they have all the information and they can say why it is that they oppose your appeal if they do. At that stage, they also have to say what documents they would rely on in opposing your appeal, and they send a list of the documents that they have about your case and about your charity. And this might be the first time that you become fully aware of the information that the Charity Commission has about your charity, so that's an important part of the process for you. At this stage, the charity that's brought the case is called the appellant in the tribunal, and the Charity Commission is called the respondent, although you don't have to worry too much about getting all the terminology right, and you can just refer to the Charity Commission as the Charity Commission. Once you've seen the Charity Commission's response and its list of documents, you have the option of sending us a reply to the Charity Commission's response. You don't have to do this, it's an optional step, but it is an opportunity for you to say anything more that you want to see now that you've seen what the Charity Commission says about your charity and have seen how it puts its case in relation to your appeal. If you do file a reply, then you have to do that within 28 days, and then the Charity Commission has a further 14 days in which to let you know whether there are any other documents it wants to tell you about as a result of what you've said in your reply. That's called secondary disclosure. But the reply and the secondary disclosure are an optional step, and you don't have to do that in every case, but you can if you want to. It sounds a bit formal, but the reason for this process of stages of exchange of information is so that by the time we come to a hearing, everybody's got their cards face up on the table, and the tribunal knows, and importantly each side knows, what each side's case consists of and how to respond to it. So it seems a little bit formal and slow, but it's for a good reason, and it's helpful then later to look back at what everybody said in those early stages of the process. The next stage is for the tribunal to issue what are called directions. Directions are really just instructions about how a case is going to proceed and a timetable for following those instructions. And those instructions take a case from the exchange of information that's been going on that I've been talking about in the early parts of a case, up to the point where we're going to have a hearing and everybody gets together and the appeal is decided. Sometimes directions can just be agreed between the charity and the Charity Commission because it's a very straightforward process and everyone's clear what's going to happen. There's not a standard form for directions, but you can have a look on our website and see directions that we've issued in other cases and see the sort of things that are included in them. They usually include directions for the filing of witness statements if there's going to be witness evidence. There won't necessarily be, but it might be relevant in your case, and so there'd be a timetable for giving your witness statements to the other side. Also directions for the preparation of what we call the hearing bundle, which is the file of papers that the tribunal is going to consider at the hearing. And we usually ask the Charity Commission to prepare that bundle because it's quite a big job. All the pages have to be given a page number and they have to be put into a folder in the same order. But the charity contributes to that process by saying which documents it wants to go into the bundle. So both sides have everything that they want before the tribunal, and don't worry about anything being missed out because you'll get a copy of it before it goes to the tribunal and you can check everything's there. We often also give directions for a bundle of authorities, and what that is copies of the Acts of Parliament and any previous decided cases that the charity and the Charity Commission want the tribunal to look at when reaching its decision, so there'll be directions for that too. And most of those cases will be available for free on the internet. There's a useful website called Bailey where most tribunal cases or other cases can be found for free. But the Charity Commission lawyers are normally really helpful in providing copies of those to a charity and making sure they know what all the legal principles are that the tribunal's going to consider. The directions are usually discussed at a telephone conference. Is very informal. You're given a code number to dial in to the telephone conference, and that's usually a judge sitting on his or her own and a lawyer from the Charity Commission and yourself. And we go through the draft directions, if there are any, or discuss what sort of things should be in the directions in your case and make sure that everybody's happy. And then the tribunal issues those in a formal document so you can refer to them for the rest of the preparation of the case. It's usual for there just to be one set of directions, but sometimes things change or people want the directions to be amended or time limits particularly extended sometimes. And that's fine, you can apply to the tribunal for that. And if it's agreed by both sides, it can usually just be done by an amendment of the document. If it's necessary to get together and discuss them, that would usually be with another telephone conference. So we try to avoid having anyone having to go anywhere or have a formal hearing before the final hearing if we can. Although sometimes people prefer to have a face-to-face meeting, and if that's your preference, then we will accommodate that. There's something called the overriding objective in the tribunal's procedural rules, and that says that the tribunal has to bear in mind the need to be fair and just in everything it does. And so when we're giving any directions or considering how a case should proceed, we always have to have regard to the overriding objective. But the rules say that the parties to a case have to have regard to the overriding objective too. And what that means is that the parties have to cooperate with the tribunal and help it to do its job. So there is an obligation on you as an appellant to meet the tribunal's directions and to cooperate and to behave in a helpful way. We're really not a sort of adversarial case that you might have seen on the television in the tribunal. Everyone's trying to work towards getting a fair resolution to the problem and deciding the case. And so we expect everyone to cooperate with each other and with us rather than trying to be tactical at this stage.